This is the federal warrant they were never supposed to execute. This is the FBI field office memorandum that crossed every line between federal and state jurisdiction. This is the moment when Donald Trump's last legal shield shattered into 1,000 pieces, and federal law enforcement made a decision that will redefine presidential accountability forever. Breaking news from multiple federal buildings across New York and Washington, D.C. has just detonated a constitutional bombshell that nobody saw coming. Friday morning, January 23, 2026, at 7:18 a.m. Eastern Standard Time, FBI agents executed search warrants at 3 Trump Organization properties in Manhattan. We are not talking about state sheriffs serving civil seizure orders. We are talking about federal criminal investigators with badges and guns entering Trump properties to gather evidence. Simultaneously, at 7:22 a.m., a separate team of IRS criminal investigation agents raided the accounting offices of Mazars USA, Trump's longtime accounting firm, seizing financial records spanning 2 decades. At 7:35 a.m., FBI agents entered the offices of Deutsche Bank in New York to execute warrants for documents related to Trump Organization loans. This is not a civil matter anymore. This is a federal criminal investigation. The Department of Justice has opened a probe into whether Trump and his associates engaged in bank fraud, wire fraud, tax evasion, and conspiracy to defraud the United States. We are talking about criminal charges that carry prison sentences measured in decades. We are talking about the sitting president of the United States being actively investigated by his own Justice Department for crimes that could land him in federal prison. Why is this happening now? Because the civil fraud case in New York uncovered evidence that federal prosecutors could not ignore. During the trial, documents emerged showing that Trump provided different financial statements to different institutions. He told banks his properties were worth hundreds of millions to secure loans. He told tax authorities the same properties were worth a fraction of that to minimize taxes. He told insurance companies his assets were worth billions to get favorable rates. These are not civil misrepresentations. These are federal crimes: bank fraud, tax fraud, wire fraud when the false statements crossed state lines. The U.S. Attorney's Office for the Southern District of New York, the most prestigious and independent federal prosecutor's office in the country, has been quietly building this case for months. They have been working with forensic accountants, financial experts, and cooperating witnesses. They have been presenting evidence to a grand jury. And on Thursday, January 22nd, the grand jury returned multiple sealed indictments. The indictments are sealed because the investigation is ongoing. But sources familiar with the matter, speaking to the New York Times and the Washington Post, confirm that Trump is among those indicted. So are several Trump Organization executives. So are outside accountants and lawyers who allegedly helped facilitate the fraud. This is the nightmare scenario Trump has been trying to avoid for 5 years. This is federal criminal prosecution. And unlike the state cases that he has been fighting, federal cases come with federal consequences. Federal prosecutors have unlimited resources. Federal judges are appointed for life and do not face political pressure. Federal prisons are not the kind of places where billionaires serve comfortable sentences. Trump's legal shield has crumbled. The walls are closing in, and this time there is no escape route. Buckle up. The next 72 hours will determine whether a sitting president becomes the first in American history to be criminally indicted by his own Justice Department while still in office. To understand why these federal raids are so devastating, you need to understand the difference between civil and criminal liability. The New York case that Letitia James brought was a civil fraud case. Civil cases are about money. The penalties are fines, disgorgement of profits, and asset seizure. You can lose your property, you can lose your business, but you do not go to prison for civil violations. Criminal cases are different. Criminal fraud requires prosecutors to prove that the defendant knowingly and intentionally made false statements with the intent to deceive. The burden of proof is higher, but the consequences are prison. Federal prosecutors at the Southern District of New York have been reviewing the evidence from the civil trial. What they found was a pattern of criminal conduct that went far beyond inflated asset values. They found that Trump and his associates created entirely fictitious financial statements. They fabricated property appraisals. They backdated documents to make loans appear more secure than they were. They used shell companies to hide income and evade taxes. This is not aggressive accounting. This is not creative interpretation of tax law. This is systematic fraud that violates multiple federal criminal statutes. The U.S. Attorney's Office briefed the Attorney General on their findings in early January. The Attorney General, who was appointed by Trump, faced an impossible decision. Does he authorize a criminal investigation of the president who appointed him? Does he refuse and face accusations of obstruction? According to sources who spoke to Politico, the Attorney General agonized over the decision for days. He consulted with career prosecutors. He reviewed the evidence himself. He met with the FBI director. Ultimately, he concluded that the evidence was too strong to ignore. If he blocked the investigation, he would be accused of protecting a criminal president. His reputation would be destroyed. The Department of Justice would lose all credibility. On January 15th, the Attorney General authorized the Southern District to proceed with a full criminal investigation. He recused himself from all decisions related to the case to avoid any appearance of conflict. He appointed a career prosecutor to oversee the matter and report directly to the Deputy Attorney General. The investigation moved quickly. Prosecutors had access to all the evidence from the civil trial. They had the financial documents, they had the appraisals, they had the bank records, they brought in forensic accountants from the FBI's white-collar crime unit. They analyzed every transaction, they traced money flows, they identified false statements. By mid-January, they had enough evidence to approach the grand jury. The grand jury heard testimony from accountants, bankers, and former Trump Organization employees who had been granted immunity in exchange for cooperation. The witnesses described a system where Trump personally directed the creation of fraudulent financial statements. They described meetings where Trump told accountants to inflate property values. They described phone calls where Trump instructed lawyers to create legal structures to hide income. The testimony was damning. On Thursday, January 22nd, the grand jury voted to indict. The sealed indictments charged Trump with conspiracy to commit bank fraud, conspiracy to commit wire fraud, filing false tax returns, and obstruction of an IRS investigation. Each count carries a maximum sentence of up to 20 years in federal prison. Trump Organization executives are charged with similar crimes. Several outside accountants and lawyers are charged as co-conspirators. The indictments are sealed pending the execution of search warrants and the arrest of lower-level defendants. Federal prosecutors wanted to secure all the evidence before Trump could destroy documents or intimidate witnesses. That is why the raids happened Friday morning, less than 12 hours after the indictments were returned. It was a carefully coordinated operation designed to execute before Trump even knew what was happening. Let's talk about what happened during the Friday morning raids because the operational details reveal how serious federal law enforcement is taking this investigation. At 7:18 a.m., a team of 12 FBI agents arrived at the Trump Organization headquarters on the 26th floor of Trump Tower. They presented a search warrant signed by a federal magistrate judge. The warrant authorized them to seize financial records, computers, emails, and any documents related to property valuations, bank loans, or tax filings from 2010 to the present. Trump Organization security initially tried to block the agents from entering. The FBI supervisor informed security that obstructing a federal warrant is a federal crime. Security backed down. The agents spent 6 hours inside Trump Organization offices. They seized computers from accounting staff. They copied email servers. They took boxes of financial documents. They photographed whiteboards and handwritten notes. Everything was cataloged and transported to FBI headquarters. Simultaneously, at Mazars USA, the accounting firm that prepared Trump's financial statements for decades, another FBI team executed a similar warrant. Mazars is a major international accounting firm. They have represented Trump for over 40 years. But in 2022, Mazars dropped Trump as a client after the New York fraud investigation began. They issued a statement saying they could no longer stand behind the accuracy of financial statements they had prepared for Trump. Now, the FBI was seizing those statements and all the underlying documentation. The Mazars raid was particularly significant because accountants keep detailed work papers. Every calculation is documented. Every assumption is recorded. If Trump told Mazars to use certain property values, there will be documentation of those conversations. If Mazars knew the values were inflated and prepared the statements anyway, they are co-conspirators. If Mazars was deceived by Trump, they become cooperating witnesses. Either way, federal prosecutors now have a complete paper trail. The raid on Deutsche Bank was the third piece of the operation. Deutsche Bank was one of the few major banks willing to lend to Trump after most American banks stopped working with him in the 1990s. Deutsche loaned Trump hundreds of millions of dollars. Those loans were secured based on property valuations that are now alleged to have been fraudulent. If Trump obtained loans by submitting false financial statements to Deutsche Bank, that is textbook bank fraud. The FBI seized all loan files related to Trump. They took copies of the financial statements Trump submitted. They took internal bank communications discussing the loans. They took risk assessments that might show the bank had concerns about Trump's representations. This evidence will be used to prove that Trump knowingly defrauded the bank. The coordination of these three simultaneous raids demonstrates the sophistication of the federal investigation. Prosecutors did not just target one location, they hit every point in the conspiracy: the company headquarters, the accountants who prepared the documents, the banks who received the fraudulent statements. They are building a case that shows the entire scope of the criminal enterprise. Now let's discuss what this means legally for Trump, because a federal criminal indictment changes everything. In civil cases, Trump has been able to delay, appeal, and drag out proceedings for years. Federal criminal cases move much faster. The Speedy Trial Act requires that criminal defendants be brought to trial within 70 days of indictment. There are ways to extend that deadline, but not indefinitely. Trump will be arraigned within days. He will be required to appear in federal court. He will be formally charged. He will enter a plea. This is not something he can skip or delegate to lawyers. A criminal defendant must appear personally. If Trump refuses to appear, the judge can issue a bench warrant for his arrest. Imagine that. A sitting president with an arrest warrant. If Trump does appear and pleads not guilty, the case proceeds to trial. Pre-trial motions will take months. But by summer 2026, this case could be in front of a jury. A federal criminal trial of a sitting president would be the most watched legal proceeding in American history. The courtroom would be packed. Every word would be televised. Every piece of evidence would be scrutinized. The trial would consume the country. Trump's presidency would be completely paralyzed. He could not govern effectively while sitting in a federal courtroom 8 hours a day. The political implications are seismic. A federal criminal indictment gives Congress clear grounds for impeachment. House Democrats will argue that a president under criminal indictment for fraud cannot be trusted to execute the duties of the office. They will draft articles of impeachment. The House will vote. The articles will pass. The Senate trial will be different from the previous two impeachments. This time, there is actual federal criminal evidence. This time, the charges are not political or partisan. They are black-letter crimes: bank fraud, tax fraud, conspiracy. Republican senators who previously defended Trump will face an impossible choice: vote to convict a president who has been federally indicted for crimes, or vote to acquit and explain to voters why they are protecting a criminal. The pressure will be enormous. And unlike the previous impeachments, this one might succeed. If 17 Republican senators decide that a criminally indicted president is too damaging to the party, they will vote to convict. Trump would be removed from office. The vice president would become president. Trump would become a private citizen, and as a private citizen, he would face immediate arrest and trial. There would be no more presidential immunity, no more Secret Service protection, no more delay tactics. He would be processed like any other criminal defendant. He would be fingerprinted, photographed. He would post bail or be held pending trial. He would face the possibility of spending the rest of his life in federal prison. Let's talk about the evidence, because understanding what prosecutors have is crucial to understanding why this case is different from all the others. Federal prosecutors do not indict sitting presidents lightly. The decision to indict Trump would have required overwhelming evidence that conviction is virtually certain. Based on reports from the New York Times, Washington Post, and Wall Street Journal, here is what prosecutors have. They have two sets of financial statements for the same properties covering the same time periods. One set values Trump Tower at $327 million for tax purposes. The other set values it at $1.2 billion for loan purposes. These documents have Trump's signature. They were submitted to federal institutions. The discrepancy is not a rounding error. It is fraud. They have internal Trump Organization emails discussing how to inflate property values. One email, reported by CNN, shows a Trump Organization executive asking an accountant to increase the square footage of Trump's penthouse from 11,000 square feet to 30,000 square feet to justify a higher valuation. The accountant objected. The executive replied that Trump had personally instructed him to use the higher number. They have testimony from former Trump Organization CFO Alan Weisselberg. Weisselberg pleaded guilty to tax fraud in 2022 and received a reduced sentence in exchange for cooperation. He has provided detailed testimony about how Trump personally directed the creation of fraudulent financial statements. Weisselberg's testimony is corroborated by documents and other witnesses. They have bank records showing that Trump received loan proceeds based on the inflated valuations. They have evidence that Trump then used those loan proceeds for personal expenses while deducting the interest as business expenses on his tax returns. This is tax fraud layered on top of bank fraud. They have proof that when the IRS began auditing Trump's returns, Trump and his accountants provided false information to IRS agents. They claimed certain business losses that never occurred. They inflated deductions. They hid income in shell companies. Lying to IRS agents during an audit is a separate federal crime. Prosecutors have all of this evidence organized into a timeline that shows a pattern of conduct spanning 15 years. This is not one mistake. This is not an accounting error. This is a systematic criminal enterprise. Defense attorneys often argue that financial crimes are complicated and that any discrepancies are just different interpretations of accounting rules. That defense does not work here. The evidence shows intent. It shows knowledge. It shows Trump personally directing the fraud. A jury will have no trouble understanding that telling a bank your property is worth 3 times what you told the IRS is a crime. Now let's discuss the constitutional crisis this creates, because a sitting president facing federal criminal charges is unprecedented territory. The Justice Department has a long-standing policy, first articulated in the 1970s during Watergate, that a sitting president cannot be criminally indicted. The reasoning is that indicting a president would interfere with his ability to execute the duties of the office. Only Congress, through impeachment, can remove a president. Once removed, the former president can be prosecuted, but not while sitting. However, that policy is just a policy. It is not a constitutional requirement. It has never been tested in court. And there is a strong legal argument that the policy should not apply when the crimes involve the president's private business conduct rather than official acts. Trump's lawyers will argue that the indictment must be dismissed based on the Justice Department's own policy. They will argue that prosecuting a sitting president is unconstitutional. They will seek to delay the case until Trump leaves office. Federal prosecutors will counter that the policy is not binding on courts. They will argue that the crimes charged have nothing to do with Trump's official duties as president. They are private business crimes that occurred before he took office and continued during his presidency. The Constitution does not shield presidents from prosecution for private criminal conduct. The district court judge will have to rule on these competing arguments. If the judge dismisses the indictment, prosecutors will appeal. The case will go to the Second Circuit Court of Appeals. Eventually, it will reach the Supreme Court. The Supreme Court will have to decide whether a sitting president can be criminally prosecuted. This is the ultimate constitutional question. If the court rules that sitting presidents can be prosecuted, it establishes that presidents are not above the law. It means that any president who commits crimes can face immediate legal consequences without waiting for impeachment. If the court rules that sitting presidents cannot be prosecuted, it creates a 4-year window where presidents are effectively immune from criminal accountability. It means that a president could commit murder and could not be indicted until after leaving office. The court is unlikely to create such broad immunity, but whatever they decide will reshape the presidency and the balance of power between the executive and judicial branches. Here is what you need to watch for over the next 7 to 10 days, because this situation is moving at unprecedented speed. First, watch for Trump's arraignment. Federal prosecutors will move to arraign Trump as soon as possible. The arraignment could happen as early as Monday or Tuesday. If Trump refuses to appear, watch for news about a bench warrant. Second, watch for additional arrests. The sealed indictments reportedly include multiple defendants. Lower-level Trump Organization employees and outside professionals will be arrested over the next week. Watch for who flips and agrees to cooperate. Third, watch for document leaks. Portions of the indictment will almost certainly leak to the press. Watch for details about what specific crimes Trump is charged with and what evidence prosecutors have. Fourth, watch for Trump's public statements. If he attacks the Justice Department, if he calls the prosecution a witch hunt, if he suggests that he will fire the Attorney General, those are signs that he is preparing to obstruct. Fifth, watch for impeachment proceedings. House Democrats will move quickly to draft articles of impeachment based on the federal indictment. Watch for how many Republicans support impeachment. If the number is significant, conviction in the Senate becomes possible. Sixth, watch for cabinet defections. If cabinet members start resigning in protest of the indictment or in protest of Trump's response to it, that signals a collapse of executive branch unity. Seventh, watch for market reactions. If the stock market drops significantly, if Treasury yields spike, if the dollar weakens further, it means investors believe this crisis will destabilize the government. Eighth, watch for international reactions. Allied governments will be watching to see if America is capable of holding its president accountable or if the country descends into constitutional chaos. Trump's legal shield has crumbled. The civil cases were just the beginning. The federal criminal investigation is the endgame. Bank fraud, tax fraud, wire fraud, obstruction. These are crimes that send people to prison for decades. These are crimes that end presidencies. The FBI raids on Friday morning were not political theater. They were the execution of a carefully planned criminal investigation that has been building for months. Federal prosecutors have evidence, they have witnesses, they have documents, they have a grand jury indictment, they have a legal case that career prosecutors believe they can win. Trump has no good options left. He cannot delay a criminal trial forever. He cannot appeal his way out of federal charges. He cannot use presidential power to make this go away without triggering obstruction charges. He is cornered, and cornered leaders make desperate choices. The next phase of this crisis will be the most dangerous. A president facing federal prison time is a president with nothing left to lose. A president who believes the system is trying to destroy him is a president who might try to destroy the system first. Watch for emergency powers. Watch for attacks on the Justice Department. Watch for attempts to fire prosecutors or pardon himself. Watch for rhetoric that incites his supporters to violence. Watch for a constitutional crisis that makes everything we have seen so far look like a warm-up. The federal agents have moved in, the evidence has been seized, the indictments have been returned, the shield has crumbled, and there is no going back. Subscribe to stay ahead of this story. Hit the bell icon so you are notified the moment the next development breaks. Share this with everyone who needs to understand that we have entered the final chapter. This is not just a legal case anymore. This is not just a political scandal. This is a test of whether American institutions are strong enough to hold a president criminally accountable. The answer will define this era, and it will be written in the coming days.